Well, a whole lot has been happening in Rivers State, call it Rivers Judiciary, but the controversy surrounding the appointment of the Chief Judge of the state is our focus next. And joining us to look at that is Osahon Ihenyen. He's a legal practitioner. Good morning and thanks for joining us.
Thank you very much.
I'm sure you've been following that particular matter in Rivers State.
Yes.
What do you make of it?
I think that what has been happening in Rivers is just I think the governor and of course the National Judicial Council, they've had a number of misgivings as to the interpretation of the relevant sections of the Constitution, Section 271, Section 158, and Section 20 of Part 3 to the schedule to the Constitution. I think there's been a lot of misunderstanding, actually, as to those the provisions of the Constitution concerning the appointment and, of course, recommendation and all that of who becomes the next CJ of Rivers State.
When you talk about misunderstanding, it would seem as if, well, there are no advices concerning legal matters or the appointments, because as you rightly put it, it is clear in the Constitution and the state has its own point. So where is this misunderstanding coming from, constitutionally speaking? I
think the misunderstanding is coming from the governor actually not knowing what exactly what his powers or whatever are, concerning the appointment of the new CJ, a CJ in the state.
Tell us the processes of appointing a Chief Justice.
The State Judicial Service Commission brings a list. The list is sent to the NJC, that is in Abuja. The NJC looks at the list, and they will recommend one person on that list, and they send it back to the governor. What the governor is then to do is really not to appoint, is to actually announce what the recommendations of the National Judicial Council is. Because what happens is a list is prepared, two members, three, whatever, people who are qualified to become the new CJ of any state by virtue of the provision of Section 271 of the Constitution. When that is done, that list, in this case, two people have been suggested, listed by the State Judicial Service Commission. And those two people have been sent to the National Judicial Council, headed by the Chief Justice of the Federation. And the National Judicial Council has now picked one of those persons. I think it's Daisy Okocha that has been picked, and they've now taken it back to the governor. Actually, what the governor is to do is to actually announce. I think the Constitution probably also created this. When you say the governor then appoints, no, the governor does not appoint. There is a separation of powers here.
Did the Constitution use the word appoint?
Yes, in some stages, if you look at Section 271, it talks about the governor appointing. The governor does not appoint. The governor, the River State Judicial Service Commission gets a list of those who are qualified to be Chief Judge of the state. In this case, they got two people, I think Agumagu, PHC Agumagu, and Daisy Okocha. That list is now sent to the National Judicial Council. The National Judicial Council now recommends one. And they tell the governor, this is the person we have recommended. The governor does not have power, as it were, to appoint the Chief Judge of the state. What he is to do is to announce. I think the mix-up came by from the provisions of the Constitution. Because if you look at the third schedule to the Constitution, Section 20, sub 3, sub C, says, sub 1, sub C, talks about when they have already picked somebody from the list, they will now say to the governor, we have recommended this person. The governor is not to look at it anymore. He's just supposed to announce that person. And of course, in exercising those powers, that the power given to NJC, you look at section 158 of the Constitution, which is also very clear. The power of the NJC to appoint the person who becomes the chief judge of a state is unfettered. It's not subject to any control by anybody, any authority, or any person. That is the provision of the Constitution.
You know, but the words you use, because I know that people always say that the Constitution is very deliberate with its words. The wording of the Constitution are usually quite deliberate. So if you have the NJC is to recommend, you know, it means that we're saying we think this person is suitable for the job, not that this is the person we have chosen. And if it says very categorically that the governor is to appoint, it means that the governor can differ with the choice that has been recommended to him. Don't you agree?
I do not agree. I do not agree. Absolutely, I do not agree.
What do you take exception to? Is it the words themselves, or it's how it's been practiced over the years?
If it were possible for the governor to just appoint the chief judge of the state, there will be no need for them to send a list to the National Judicial Council. And for them to now recommend out of the people on the list, the persons on the list, they recommend out of the persons on the list. Remember that the State Judicial Service Commission is, of course, under the, how do I put it now? Is, of course, controlled by the governors of the state. So when the State Judicial Service Commission now brings up a list of 2 persons, they send that list to the National Judicial Council. When the National Judicial Council now says, we have chosen this person, I think that is the end of the matter. The governor does not have a choice to now go back to start looking at the list that was in the first place sent by the State Judicial Service Commission, which is under the control of the governor.
If the Constitution wanted the governor to just announce, one would think that it would use that word, announce. You don't think so?
No, that's the point I'm making. That's the point I'm making. The Constitution probably also created these issues because it makes the governor feel, oh, I have powers to appoint. If he had powers to appoint, why did he have to send it to the NJC? He shouldn't have. He should just appoint. But you see, the framers of the Constitution had at the back of their minds a situation where the governor or the chief executive of the state will want to pick somebody who he can manipulate. And they also had at the back of their mind, you know, separation of powers, as entrenched, of course, in presidential constitutions. That is why it is not made so that the governor will just say, oh, I want XYZ to be the new chief judge of the state, and that becomes law.
But the Federal High Court has actually voided the move of the NJC, recommending Okocha as the CJ of the state.
The Federal High Court has Okocha, you mean?
Yes. You know, there's a judgment of the Federal High Court.
Yes.
So
I'm aware of that.
You're aware of that. And some say, well, that amounts to, well, flagrant disregard of...
I'm also aware that the NJC has appealed that decision. They've appealed that decision.
What comes first, the appeal or adherence to a judgment before appeal?
If you ask me, the position should actually be that when you appeal, everything is stayed, as it were. When you appeal, everything is stayed, because without wanting to go into the whys and the whatever of the judgment itself, I remember that the Justice Lambo Akombi did talk about the NJC not giving a reason why they did not appoint Agumago. That is not in the Constitution. It is not said there that the NJC will now give a reason after you have given them a list, that they will now say, okay, we want A, we do not want B. This is our reason for not wanting A, this is our reason for not wanting B. No. I think, to some extent, I think the judgment went beyond. In fact, the judge himself took some issues that were not put before it. You know, and you cannot go on and pronounce as it were, on things that are not put before you. The law is clear. The Constitution is clear.
If I may come in here.
Yeah, please do.
Agumago, there's a case about his suspension. If the NJC, if the High Court has voided the appointment of Okocha, there's a case that is still pending, and I think one of the protests that happened in Rivers State about Okocha's appointment had to do with the fact that there's a case pending on the suspension of Agumago. Why is the NJC going ahead if there's a case?
NJC has powers to suspend Agumago, but they do not have powers to remove him without recommending such to the governor. That is what the Constitution says. NJC has powers to decide disciplinary measures as it concerns their members. I mean, Agumago, Daisy Okocha, they are members of the, as it were, judiciary arm of the government. And they have powers to discipline them.
Okay.
And in disciplining them, the governor does not have a say in the disciplining of judges. What the governor has a say in is when that judge is to be removed. Again, the Constitution is clear on that matter. Very clear.